Attention everyone, if you hold dual citizenship or you're planning to become a dual citizen, what I'm about to tell you could completely change your status in February 2026. The United States is making major changes to dual citizenship laws that could affect millions of people. And if you don't know about these changes, you could lose rights, face penalties, or miss critical deadlines. Stay with me because this is breaking news you cannot afford to miss. I'm your host, and today we're covering one of the most significant immigration policy updates in recent years. The dual citizenship law changes coming in February 2026 are going to impact dual citizens, green card holders seeking citizenship, and anyone with ties to multiple countries. Whether you were born with dual citizenship, acquired it through marriage, or naturalized as a U.S. citizen while keeping your original nationality, these changes will affect you. So, let's dive deep into everything you need to know to protect your status and your rights. Let me start by explaining what dual citizenship actually means under current What is Dual Citizenship? U.S. law. The United States recognizes dual citizenship, which means you can be a citizen of the U.S. and another country at the same time. Unlike some countries that require you to renounce your previous citizenship when you naturalize, the U.S. has generally taken a permissive approach. However, and this is crucial, the U.S. has always maintained that when you're on American soil, you're considered an American citizen first and foremost. You must use your U.S. passport to enter and exit the United States. You must pay U.S. taxes on your worldwide income, and you're subject to all U.S. laws, including potential military draft registration. Now, February 2026 brings significant changes to how dual citizenship is recognized, reported, and managed. The first major change coming in February 2026 is the new dual citizenship registration requirement. Starting February 1st, all U.S. citizens who hold citizenship in another country will be required to register their dual citizenship status with the Department of Homeland Security through a new online portal. This is completely new. Previously, there was no formal requirement to notify the U.S. government that you held another citizenship unless you were applying for security clearances or certain government positions. Now it becomes what's changing in February 2026 mandatory for everyone. You'll need to provide information about which other countries you're a citizen of, your passport numbers from those countries, and whether you've served in foreign militaries or held foreign government positions. The registration deadline is 6 months from February 1st, which means you have until August 1st, 2026 to comply. Failure to register could result in penalties, including fines up to $5,000, and potential complications with passport renewals, security clearances, and even naturalization applications for family members. The government is creating this database for national security purposes to better track individuals with ties to multiple countries, especially those from nations considered high risk or adversarial. The second critical change involves enhanced reporting requirements for dual citizens working in sensitive fields. If you're a dual citizen working for the federal government in defense contracting and intelligence agencies in critical infrastructure or in positions requiring security clearances, the requirements are getting much stricter. In February 2026, you'll need to report not just your own dual citizenship, but also the foreign citizenship status of immediate family members, including parents, siblings, spouses, and children. You'll need to disclose any financial accounts, property ownership, or business interests in your other country of citizenship. You'll be required to report any contact with foreign government officials from your other who is affected the most country of citizenship, even if it's routine or social. For many dual citizens in these fields, this could mean additional scrutiny during security clearance reviews, or even being moved to positions that don't require clearances. Some agencies may implement policies that effectively limit advancement opportunities for dual citizens in sensitive roles. If you work in any of these sectors, you need to consult with your security officer or HR department immediately to understand how these changes will affect your career. The third major change affects dual citizens and their travel patterns. Starting February 2026, U.S. Customs and Border Protection will be implementing enhanced screening for dual citizens, particularly those traveling frequently between the United States and their other country of citizenship. The new system will flag dual citizens who spend extended periods more than 6 months per year outside the United States, especially if that time is spent in their other country of citizenship. While this doesn't change your citizenship status, it could trigger additional questioning at ports of entry and potentially impact future applications for bringing family members to the U.S. or sponsoring relatives for green cards. Immigration officers will have access to the new dual citizenship registry and will be able to see your travel patterns across both passports. There's concern in the immigration legal community that this could be used to question the strength of dual citizens' ties to the United States. If you're a dual citizen who travels frequently or maintains significant presence in another country, you should document new restrictions and requirements your U.S. ties clearly, maintain a U.S. residence, file U.S. taxes properly, and be prepared to explain your travel patterns if questioned. The fourth significant change involves tax reporting and compliance requirements for dual citizens. The IRS has always required U.S. citizens to report worldwide income, regardless of where they live, but enforcement is getting much more aggressive in 2026. The Treasury Department is implementing new information sharing agreements with dozens of countries, which means foreign banks and tax authorities will be automatically sharing information about accounts held by U.S. citizens with the IRS. If you're a dual citizen with financial accounts, investments, or property in your other country of citizenship, the U.S. government will increasingly have visibility into those assets. The Foreign Bank Account Report, known as FBR requirements, aren't changing, but enforcement is ramping up dramatically. If you have more than $10,000 in foreign financial accounts at any time during the year, you must file an FB. Failure to file can result in penalties of $10,000 per violation per year, and in cases of willful violation, penalties can be 50% of the account balance or $100,000, whichever is greater. The new change in 2026 is that the Dual Citizenship Registry will be cross-referenced with FBR filings and tax returns. If you've registered as a dual citizen of a particular country but haven't been filing FBRs or reporting foreign income, you can expect to be flagged for travel, passport, and legal impact audit. My strong advice is to consult with a tax professional who specializes in international taxation. Review all your foreign accounts and assets, ensure you're in compliance with FBAR and foreign income reporting. And if you've missed filings in the past, consider the IRS streamlined filing compliance procedures or voluntary disclosure programs to get compliant before enforcement actions begin. The fifth area of change is around dual citizenship and military service obligations. Some countries require their citizens to perform military service. And if you're a dual citizen, you might technically be subject to those requirements even while living in the United States. Starting February 2026, the State Department is implementing new policies regarding dual citizens and foreign military service. If you're a dual citizen and you voluntarily serve in a foreign military, especially in a combat role or as an officer, you could face potential loss of U.S. citizenship. This isn't entirely new. The law has always said that serving in a foreign military with the intent to relinquish U.S. citizenship could result in loss of citizenship, but proving intent was difficult. The new policy shifts the burden. If you serve in a foreign military, you'll be presumed to have intended to relinquish citizenship unless you can prove otherwise. There are exceptions for compulsory service where you have no choice, and for service in militaries of allied nations in non-combat roles. But if you're a dual citizen considering military service in your other country, common mistakes to avoid you absolutely must consult with an immigration attorney first because you could inadvertently lose your U.S. citizenship. Additionally, dual citizens who have served in foreign militaries will need to disclose this in their dual citizenship registration, and it may affect their ability to obtain security clearances or work in certain fields. The sixth change involves dual citizenship and the naturalization process for new citizens. If you're currently a green card holder planning to apply for U.S. citizenship, there are important changes in February 2026 regarding what happens to your original citizenship. The oath of allegiance that new citizens take includes language about renouncing foreign allegiances, but the U.S. has never required actual formal renunciation of previous citizenship. That's still true, but the process is becoming more transparent. Starting February 2026, during naturalization ceremonies, immigration officers will explicitly inform new citizens about their obligations regarding dual citizenship, including the new registration requirement, tax obligations, and travel requirements. New citizens will receive written materials explaining that if they maintain their previous citizenship, they must register it within 30 days of naturalization. They'll also be informed about which countries do and don't recognize dual citizenship. What you must do now. Countries automatically terminate your citizenship when you naturalize elsewhere, while others allow you to keep it. Countries like China, India, in most cases Japan, and several others don't recognize dual citizenship. So naturalizing as a U.S. citizen means you automatically lose citizenship in those countries under their laws. Other countries like Canada, the United Kingdom, France, Mexico, and many others do allow dual citizenship. The change in 2026 is that this information will be clearly provided to naturalizing citizens, and there will be mandatory acknowledgement that you understand your ongoing obligations if you maintain dual status. The seventh critical area involves dual citizenship and political participation in foreign countries. This is a sensitive topic that's getting new attention in 2026. U.S. law doesn't prohibit dual citizens from voting in foreign elections or participating in foreign political processes. However, starting February 2026, dual citizens who hold or run for political office in a foreign country could face enhanced scrutiny and potential citizenship consequences. If you're a dual citizen and you're elected to a foreign legislature, appointed to a foreign government position, or work as a foreign diplomat, the State Department will review whether your actions constitute an intent to final advice and key takeaways relinquish U.S. citizenship. The law provides that taking an oath of allegiance to a foreign state could be grounds for loss of citizenship. Previously, this was rarely enforced except in extreme cases, but the new policy indicates more active monitoring. If you're a dual citizen involved in politics in your other country of citizenship, you need to be very careful. Voting in foreign elections is fine. Participating in campaigns is generally fine, but accepting formal government positions, especially those requiring an oath of office to a foreign government, could jeopardize your U.S. citizenship. The key is intent. If you intend to maintain U.S. citizenship and your foreign political involvement doesn't demonstrate intent to abandon it, you should be okay. But it's a gray area that requires legal guidance. The eighth change affects dual citizen children and families. Many U.S. citizens don't realize that their children born abroad might automatically have dual citizenship. If you're a U.S. citizen and your child is born in another country, the child is usually a U.S. citizen by birth through you, but might also be a citizen of the birth country under that country's laws. Starting February 2026, when you apply for a consular report of birth abroad or a U.S. passport for a child born overseas, you'll be required to disclose whether the child has or is eligible for citizenship in another country. This information will be entered into the Dual Citizenship Registry. Parents will be responsible for registering their children's dual citizenship status and keeping it updated. This is particularly important for families that move between countries or maintain ties to multiple nations. The government wants to track dual citizen children for several reasons, including potential inheritance of security clearance issues if parents work in sensitive fields, and to ensure proper tax compliance as children grow up. For families with dual citizen children, this means more paperwork and ongoing reporting obligations. But it also means the government will have better records, which could actually be helpful when children later apply for passports or need to prove citizenship. The ninth area of change involves dual citizenship and immigration benefits for family members. If you're a U.S. citizen sponsoring family members for green cards or immigrant visas, your dual citizenship status may now be a factor in processing times and scrutiny levels. Starting February 2026, if you're a dual citizen petitioning to bring a spouse, parent, child, or sibling to the United States, immigration officers will consider your travel patterns, residential history, and ties to your other country of citizenship when evaluating whether the immigration benefit should be approved. The concern is about so-called paper citizens, people who are U.S. citizens but live primarily abroad and use their U.S. citizenship mainly to immigrate family members. If you're a dual citizen living in your other country of citizenship and you're trying to sponsor family members for green cards, you may face requests for evidence showing strong ties to the United States, intent to relocate to the U.S. with your family member, financial ability to support them in the U.S., and documentation of visits to the United States. This doesn't mean dual citizens can't sponsor family members, but the scrutiny level is increasing and you'll need to demonstrate genuine U.S. residence and domicile. The 10th and final major change I want to cover is about dual citizenship and renunciation procedures. Interestingly, while these new requirements might seem restrictive, the U.S. government is also streamlining the process for those who want to renounce either their U.S. citizenship or their foreign citizenship. If you're a dual citizen and you decide you no longer want to maintain dual status, you have options. To renounce U.S. citizenship, you must appear in person at a U.S. embassy or consulate abroad, sign an oath of renunciation, and pay a fee, currently $2,350. This is a serious decision that's nearly impossible to reverse, and you should never do it without consulting tax and legal professionals because there can be significant tax consequences, including an exit tax on your worldwide assets if you meet certain thresholds. Starting February 2026, the State Department is implementing a mandatory counseling session before renunciation appointments where they'll explain all the consequences, including losing the right to live and work in the U.S., potential difficulty visiting the U.S., and tax implications. On the other hand, if you want to renounce your foreign citizenship to simplify your status, many countries have procedures for this. Some countries make it difficult or expensive, while others have straightforward processes. The new Dual Citizenship Registry will include information about renunciation procedures for various countries to help people who want to maintain only U.S. citizenship. For most people, maintaining dual citizenship is beneficial. It gives you flexibility for travel, work, and living in multiple countries. But for those in sensitive government positions or those who find the compliance burden too heavy, renunciation of one citizenship might be the right choice. Now let me give you some practical action steps based on these changes. First, if you're a dual citizen, mark your calendar right now for the registration deadline of August 1st, 2026. You need to register your dual citizenship status within 6 months of February 1st. Set reminders and don't wait until the last minute because the system might be overwhelmed. Second, gather your documents, including all passports, citizenship certificates, birth certificates, and naturalization documents for yourself and your family members. You'll need this information for the registration process. Third, review your tax compliance. Are you filing FBRs if required? Are you reporting all foreign income? If you're not sure, consult with a CPA or tax attorney who specializes in international tax law. It's better to get compliant now before enhanced enforcement begins. Fourth, if you work in a sensitive field or have a security clearance, talk to your security officer about how these changes might affect you. Don't wait for them to come to you. Fifth, if you travel frequently between the U.S. and your other country of citizenship, start documenting your U.S. ties. Keep records of your U.S. residence, employment, family ties, financial accounts, and community involvement. Sixth, if you have children with dual citizenship, make sure you understand your obligations to register them and maintain their documentation. Seventh, if you're planning to naturalize as a U.S. citizen, understand that you'll need to register your previous citizenship within 30 days and comply with all ongoing requirements. Eighth, consider consulting with an immigration attorney, especially if you have complex situations like foreign military service, foreign government employment, or if you're in the process of sponsoring family members. These changes create legal complexities that benefit from professional guidance. Ninth, stay informed because implementation details are still being finalized. Check the USCIS, State Department, and DHS websites regularly for updated guidance and instructions. 10th, join communities of dual citizens, whether online forums or local groups, where people share experiences and information about navigating these requirements. Let me address some common concerns and questions I know people have. First, can the U.S. government force you to give up your other citizenship? No, the United States cannot force you to renounce citizenship in another country. What they can do is create requirements and obligations that make dual citizenship more burdensome, or in extreme cases determine that your actions constitute voluntary relinquishment of U.S. citizenship, but they cannot compel you to renounce foreign citizenship. Second, is dual citizenship still legal after February 2026? Yes, absolutely. The United States continues to recognize and allow dual citizenship. These changes are about registration, reporting, and compliance, not about prohibiting dual citizenship. Third, what if my other country doesn't allow me to renounce citizenship? Some countries like Morocco, Argentina, and several others make renunciation very difficult or effectively impossible. The U.S. understands this, and you won't be penalized for maintaining citizenship you can't legally renounce. You just need to register it and comply with U.S. obligations. Fourth, what if I didn't know I had citizenship in another country? Some people automatically have citizenship through parents or grandparents without realizing it. If you discover you have dual citizenship, register it as soon as possible. The government is more lenient with people who genuinely didn't know versus those who deliberately concealed it. Fifth, will these changes affect my ability to travel? Not directly. You can still travel freely as a U.S. citizen. However, you may face more questions at the border if your travel patterns raise flags. So, be prepared with documentation and explanations. Let me also discuss some specific country considerations because dual citizenship issues vary depending on which countries you're a citizen of. If you're a U.S. and Canadian dual citizen, you're generally in good shape. The U.S. and Canada have strong information sharing and dual citizenship is common and well understood. Just make sure you're compliant with tax obligations in both countries. If you're a U.S. and Mexican dual citizen, similar situation, close relationship between the countries, common dual citizenship, but make sure you understand Mexican tax obligations and U.S. foreign income reporting. If you're a U.S. and European Union country dual citizen, be aware that EU countries share information extensively with the U.S. under various agreements. Your foreign financial accounts are likely already being reported to the IRS, so ensure compliance. If you're a U.S. citizen with citizenship in a Middle Eastern country, expect enhanced scrutiny, not because of discrimination, but because of national security concerns. Register promptly, document your ties to the U.S., and be prepared for additional questions. If you're a U.S. citizen with citizenship in China, be aware that China doesn't recognize dual citizenship. So under Chinese law, you're not Chinese anymore if you naturalized as American. However, if you were born with both citizenships, the situation is more complex. If you're a U.S. and Israeli dual citizen, there are specific considerations around Israeli military service obligations. Israel does allow some exemptions and deferrals for dual citizens living abroad, but this is an area where you need legal advice. One more critical point about enforcement and penalties. The government is taking these new requirements seriously, and they have significant enforcement tools. They can deny passport renewals, revoke security clearances, audit tax returns, impose fines, and in extreme cases of fraud or national security concerns, even initiate denaturalization proceedings. I'm not saying this to scare you, but to emphasize that compliance is important. The good news is that if you register honestly, report accurately, pay your taxes, and follow the rules, you have nothing to worry about. These changes are primarily aimed at closing security gaps and ensuring tax compliance, not at making life difficult for ordinary dual citizens. The vast majority of dual citizens who comply with the requirements will experience minimal disruption to their lives. So, in summary, The February 2026 dual citizenship law changes bring mandatory registration requirements, enhanced reporting for sensitive positions, increased travel scrutiny, aggressive tax enforcement, new policies on foreign military service, greater transparency in the naturalization process, attention to foreign political participation, tracking of dual citizen children, consideration in family immigration cases, and streamlined renunciation procedures. These changes reflect evolving national security priorities and the government's desire for better tracking of individuals with ties to multiple countries. While dual citizenship remains legal and valuable, it comes with increased responsibilities and compliance obligations. The key to navigating these changes successfully is to stay informed, register on time, maintain proper documentation, comply with tax obligations, and seek professional help when needed. Thank you so much for watching US Visa Info. This is critical information that every dual citizen needs to know. So please hit that like button and share this video with friends, family members, and anyone else who holds dual citizenship. Subscribe to US Visa Info and turn on notifications so you don't miss any important updates as implementation details emerge over the coming months. Drop a comment below telling me if you're a dual citizen, which countries you're a citizen of, and whether you have concerns about these changes. I read every comment, and I'll try to address common questions in future videos. Here at US Visa Info, we're dedicated to keeping you informed about immigration law changes, visa updates, citizenship requirements, and everything you need to navigate the U.S. immigration system successfully. We'll continue covering these dual citizenship changes as more information becomes available, including step-by-step guides for the registration process once the portal launches. Stay informed, stay compliant, and protect your status. Thanks again for watching, and I'll see you in the next